So the original charges was count 1 was engaging in sexual activity with a child and familiar custodial authority. That was actually a PBL, but that charge, when it's input into the arrest form, it looks like an F1. So on that count, he was given 10,000. Then on count 2, it's sexual battery of a victim 12 to 17 years of age. That's an F1. That was another $10,000 bond. And then count 3 is count 5 on the information.
Okay. All right. So as it relates to the new information, the court is going to, on count 1, the defendant will be given a bond of $10,000. On count 2, the defendant will be given a bond of $10,000. On count 3, the defendant will be given a bond of $10,000. On count 4, the defendant will be given a bond of $10,000. On count 5, that will be a $1,000. And count 6 will be $5,000 bond. Does corrections have that? Clerks have that as well? Yeah. Okay. So he is going to need to post those additional amounts. If it was $21,000 originally, it's now going to be $46,000 additional bond. That's as to that issue. Anything further on that issue, and then we're going to get to the stay away order.
So, Judge, I do think it's important to note that he is a California resident. So I would ask that Your Honor consider that when setting the bonds. Are these standard bonds, Judge?
I do not know what is considered a standard bond on these, but these are the bonds that the court's going to be giving.
Okay. So, no, Judge, I'll be filing a motion to increase bond due to the facts of the case. The other, in addition to the bond, Judge, it's just a stay away order, I think, that we can address today.
Understood. All right, anything further from the defense as to the bonds for right now?
Your Honor, I don't see that the state has laid any grounds for why the bond amount should be increased.
Well, we're not there yet. We're not there yet. There's no discussion right now. That's not what's before the court. The court just is setting bonds on the new counts.
These counts are down filed. I just want to make that clear from the record, even though there's more of them.
Understood.
So but we would object to the entire bond amount increasing, considering these are down filed charges.
Okay. The objection is noted.
Other than that, no.
All right. As it relates to the stay away order, okay. So apparently these are minors. If I can have the defendant sworn.
Mr. Noah, can you unmute yourself?
Raise your right hand. Do you swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes. Okay, sir, you can put your arm down. Can you tell me your full name and your date of birth?
Michael Eugene Note Jr., born August 10th, 1983.
All right, thank you, sir. All right, so you are currently charged under case F21 14438 with several counts involving a minor victim. And the minor victim is identified as T like Thomas, S like Sam. Do you know who that is? All right.
Yes.
Sir, you are ordered that you can have no contact with TS. And when I say no contact, that means no direct contact or indirect contact. Indirect contact includes you cannot communicate with this individual via social media, you cannot call, you cannot text, you cannot reach out to this individual or in some way attempt to communicate through a third person. Do you understand that, sir? All right, now,
yes, I do.
I will just advise you and admonish you, this means what it says. I do not know whether or not you were given any type of a stay-away order, but as of right now, this stay-away order is in effect, in that if you violate any terms of this stay-away order, that may be grounds for your bond status, your pretrial release status to be revoked, and you will be immediately taken into custody. Do you understand that, sir? Okay,
Yes,
anything further on that issue from the state?
No, Your Honor.
Anything further from that issue from the defense?
No, Your Honor.
All right, that is all that the court has before me. Are we done? Ms. Garcia?
I believe so, Judge. I just want the defendant to be aware that he should not be posting any social media posts or anything about this case, about the victim in this case. I know that there was a video of the victim leaked on social media. I'm concerned about the victim's, well-being regarding this case. So I just want to make sure the defendant's well aware that if that happens, we will be filing the appropriate motions to avoid that from happening.
All right, just so it's clear. Yeah, just so it's clear, I just want both sides to know, allegations are allegations. I certainly will respond to some type of evidence shown to the court that the defendant has somehow violated the court's order. Now let me hear from the defense.
Judge, I just want to make clear for the record as well that this arrest, Mr. Nowak has been compliant and has known about this investigation for far before his arrest, has come down and voluntarily submitted 2 warrants along the way because he has nothing to hide. Any allegations that the state is making about their fear that he might have been tampering or attempting to scare the alleged victim via social media, there's no order saying that he is not allowed to use social media. And I also would like to make clear that it took the state till 4:56 p.m. on the night before the arraignment to file an information here, and a reduced one. They were so scared, they had ample opportunity to file a motion in the meanwhile, and they failed to do so. So I don't believe that Your Honor has taken into consideration any of the arguments that they've put forth regarding why they believe bond should be increased, because that's inappropriate.
We're not there. I'm not even entertaining it. So let's not even. I don't even want to hear anything about it because nothing's before me as to an increase.
Well, Your Honor has the ability to set the additional counts at ROR.
Well, I'm not. I can tell you I'm not. Based upon the only thing I have in front of me is an information. That's what I've decided as far as the bond is concerned. That's it. Nothing more, nothing less.
Well, we would object to Your Honor taking into consideration any of the statements made by Ms. Garcia in reaching that determination.